I'm going to start on a different tone. I'm guessing that you guys have a lot to do. I'm guessing that you have teaching responsibilities, research responsibilities, papers to mark, trying to get your publications underway, working on your careers, and so forth. And I think that one of our challenges, that is those of us who are talking to you about fair and open and legal and ethical issues, isn't to, our main task, I think, is to actually give you a reason to care about this stuff. If you're all researchers, we're all researchers, we know usually where to go to find information, to handle it, and so forth, although it's obviously helpful to have short guides, modular level information, and so forth. But for me, the real challenge with this material is finding a reason to teach it, to present it in workshops, to talk to our peers about it, and so forth. And for me, that reason has a great deal to do with what's happening to the broad, and I do mean in the public domain now, reputation about research and researchers and data in the world, which I think is sinking relatively quickly. And I think it's a problem, and I don't think it's a problem just for public policy and so forth. I think it's basically a problem for all of us who are, what I would say, in the research data business of one kind or another, those of us doing research. So, yeah, Cambridge Analytica was probably the biggest thing, obviously. Now, those of us who know the details of that story, yes, there were university researchers involved. They were not the ones directly responsible for breaching the data. My view is, in the public domain, those nuances don't really make very much difference. The name Cambridge is on the name of the scandal, and university researchers were indirectly involved. Therefore, the public, I think, sees that as a problem. More to the point in this link here, does anyone remember the Ashley Madison data breach? You know that name. It was more US based, okay, a couple nods. It's not the most savory story, but Ashley Madison is a website more or less really designed for people who were married or in relationships to find partners with whom they could have affairs. It really was marketed that way. The tag was life short, have an affair. The data was breached from that website. So, okay, not good. The initial breach, of course, was a problem. For me, the problem is 5 papers done by academic researchers in refereed journals that got published based on that data. Okay? Now, something to me is wrong in a world where that can happen, where there isn't something going on where researchers would ask themselves questions about using data in that way for these purposes. So that's okay, end of rant. Now I shall try and go back to my normal mode of delivering dry material on legal and ethics and so forth. But this is why I think it matters. This is why I think, this is why I get up in the morning to do this kind of work. The reason where it connects is that as the reputation for researchers declines, there is, I think, a reaction that is pretty direct. People want to hold their data more closely. You're seeing this in language about my data, privatization of data, commodification of data, and so forth. Data as a resource, data as oil. This movement does not help researchers, does not help those of us in the community who see data as a shared resource for our common good to share amongst responsible people trying to address severe problems in the world, be those social science-based problems, climate change problems, or anything else. So I think that we need to instill better practices, obviously, and shift this mentality away from my data and commodification to the idea of data as this shared common or resource for our common good. Okay, like I said, now on to the dry, boring legal and other matters. The agenda is pretty similar. I will go through some ideas about learning goals, talk about legal issues in the general data protection regulation in particular, address a bit on ethics and informed consent, and then point you to example exercises and resources and references, which I will have say a few things about. I will very much hope to manage our time such that there can be at least, there will be some time at the end of this. I don't think we'll actually have time to do an exercise, and it isn't particularly relevant for you to do a classroom exercise here, but I think it's worth looking at them and having a short chat in smaller groups about whether or not these exercises work. Are they things you could actually use in your classroom? If not, what might work better, and what could we design for you that might work better? Okay, so learning goals, these are a bit of a mix. So partly these are things I would like to accomplish with you today, but these are also the kinds of things that you could share with students if you were teaching this. So the problem, a few years ago, the actual quantity of material out here and this complexity of issues was such that, I won't say there wasn't a lot of stuff you could do, but it was much less. The problem now is it's actually vast. There is vast literature on ethics, on legal, and copyright, and so forth. So I am thinking that given scarce resources in class time, to devote even a full day to these topics may be more than you can manage. I don't know. Feedback from you on this kind of idea is useful. Do you need 5-minute blocks of content because that's all you have time for? Could you run a half-day session on this sort of material? We're trying to develop further material, so that feedback would be helpful. Anyway, so get across some basic ideas about ethics, ethical issues that arise when sharing, publishing, and archiving data. This most explicitly is not to cover the basics about consent and so forth for core research activities. You're all teaching methods. This is stuff I'm assuming you're reasonably familiar with. If not, you can certainly ask questions. Basic knowledge about the general data protection regulation. I think most people, I'm assuming, will have heard of it. I'm not a legal expert. All the usual disclaimers apply here. I am not attempting to help people become experts in data protection law. That's not the responsibility. I think there's a general level of awareness that is necessary. There are a handful of quite specific actions that need to be taken regarding things like gaining informed consent, particularly for personal data, which we'll come back to. A lot of what I want to get across, though, is myth busting, getting rid of other people's misunderstandings. So if members of your public, your students, or a member of an ethics review committee comes to you and says, you can't do that because of GDPR, you need to be informed. You need to know whether or not that is true or not, and because there are many people, ethics committee members and others, who are saying that sort of thing when it is not true. And that's important to know. It doesn't put a researcher in an easy position, but it's good to have the information you need to have the argument. And yes, strategies for sharing and archiving, consent. I'm not going to be spending much time on the issues around de-identification, access controls, copyright and ownership. They're a bit more technical. They're easier to read about on your own. And there is a load of material from the CESTA expert guide and other sources on these topics. So it's simply a matter of what we could afford to have time to cover today. Okay. So before I go there, any comments or questions so far? Clear? Okay. So let me jump into the data protection regulation to start. So again, obviously from an archive standpoint, and a researcher standpoint from that matter, anything that adds to the bureaucracy, the regulation, more hoops we have to jump, more stuff we have to do, I'm not happy about it either. It's a real pain for us. For archiving in particular, it's a real pain. However, the goal of the regulation, I have to admit, is a good one. As a data subject, as somebody, who has my private data out there in the world, partly, it is attempting to do good things about protecting that data and giving us more rights and control over that data. So let me go through the core principles, and I'm really trying to be selective here. As I said, this is a level of general awareness, but I'm trying to pull out just the key points that honestly, if I were perhaps, for example, in your situation of embarking on a new research project, possibly dealing with sensitive data across national boundaries, international funding, what next? What you do on Monday morning, okay? And I think some of the material later in the talk and in the packet and so forth, we'll get to those questions. So the principles: process lawfully, fairly, transparent. used for a specific and legitimate purpose, relevant to the original purpose, accurate, fix errors, stored only as long as needed, and secured. Two key principles to keep in mind for the regulation are transparency, being clear about what you're doing and why, and not gathering or collecting more data than you need, the data minimization principle, and also documentation. So broadly speaking, you know, in a realm where there isn't there are a lot of case laws started now, there are many suits underway, there's not very much, the regulation itself is ambiguous, there's no doubt about it. It's partly badly written and there's a great deal of internal tension and contradiction in it. But I think the best advice I can give to people proceeding now is simply use good, sensible research, you know, practice and document what you're doing so that you can prove that you have thought about these questions and taken steps to deal with issues about data protection. And if you take away one thing around GDPR, then at least take away the idea of documenting what you do carefully. Okay, now, if you look at principles like only used for specific purposes, don't hold the data any longer than necessary. This would seem to prohibit using personal data of any kind for research, but it does not because of what's called the research exemption within GDPR. And that is that processing for archiving purposes in public interest for historical research, statistical research is permitted under the conditions of appropriate safeguards, and in particular with additional what are called technical and organizational measures to help protect that data. And we'll come to and again, you know, GDPR is great at laying down some of these grand ideas and concepts. It's quite a bit weaker on the specifics of precisely what that looks like, but in some cases they do give you a pretty good idea of some things to do. But basically what the research exemption means is that you can further process the data, so you can use it for different things than what it was originally collected for, and you can store it for longer than that minimum necessary. So it is perfectly legitimate, for example, for data archives to hold data in perpetuity. This is defensible under the GDPR because there is a reason for doing it. Okay. So there are a few kind of relevant bits, I think, to know about the scope of the GDPR, where and to whom it applies. And it applies to personal data. Personal data, okay, data that identifies a living individual. The easiest things are these kind of obvious ones that we usually know about from research: basic ID numbers, national identification numbers, but also, of course, names, phone numbers, geolocation coordinates, IP addresses, and these various items are considered personal data. There's some things, again, to pay attention, especially if you're in this realm of doing international work of any kind. If you are based in the EU and collecting personal data on anyone in the world, because you are based here, you are covered by GDPR. So that is relevant. If you are based outside the EU but collecting data about EU citizens, then you are also covered. So the scope slightly varies in that way, which is important to know about. Okay, GDPR is not exceptionally helpful in this area of pseudonymized, de-identified, and anonymized data, not providing consistent definitions across those terms. The emerging definitions that I'm seeing people cite are pseudonymized data is data where the ID has been removed, the data is an identifier is not with the existing data set, but that link may exist still somewhere, okay? And this is in some ways obviously necessary for research terms if you are doing longitudinal work, for example, where you have to keep track of people. But if that link exists anywhere, even if it's in separate data sets, separate countries, that data is deemed pseudonymized, not de-identified or anonymized, or excuse me, at least not anonymized, and therefore still within scope of GDPR. This expands the scope quite a bit if you are keeping the link to identifiers somewhere with your data. Anonymized data are out of scope, not covered by GDPR, and that should be a sort of get out of jail free card, as I would say in English. I don't know if that translates well into colloquial, but anyway. And in a lot of cases, this works. If we're talking about data that are not highly sensitive, not many identifiers, they can be completely removed, and those links are, those IDs and links are destroyed. You have an anonymized data set. The problem, of course, is that our world of binary, anonymized, and de-anonymized is, I would say, slowly, or maybe not so slowly, ending. As linkage becomes more possible, as huge quantities of identifiable data are out there and expanding in the public domain, this is simply not as clear a picture as it used to be. So it's not anything that we can completely resolve except to use good judgment and look to good practices from some existing projects about how to proceed. But it is the case that there is still a classification of anonymized data that is outside the scope for GDPR. So another quick definitional point that comes up later, just to, if you have not heard this term, of special categories of data, a subset within personal data that includes race, religion, health, matters of sex, sexual orientation, political affiliation, trade union membership. There are a handful of others that are in the notes in the PowerPoint also. These need special treatment, and we'll come to that later. Okay, I'm going to pause. Questions? I assume people had heard of GDPR, at least had people heard of GDPR? Okay. Scared of it, dealing with it directly in any way, or? I see the smiles. I would like this problem to go away, but I know I have to deal with
it. We just added, for instance, like a passage into our consent forms that was like passed from the administration to us, and this is how 5 dealt with it.
Yeah, and not a bad. I mean, honestly, you know, again, there are gradations about, you know, if. Well, we'll come to it, but precisely, you know, that may be sufficient, you know, and that can be good. Okay, well, under the scope of GDPR, there are different grounds, different basis, justifications, which a data controller or processor can use for processing data. I'm not going to spend too much time on this. It comes up in one particular point later dealing with how you structure a consent form, so I'll come back to it there. Basically, if you are doing what I'm going to call anything like traditional social science research, where you have contact with your participants and you're already going through consent procedures, almost certainly your grounds for processing is going to be consent to the data subject, and you're going to be doing that anyway. You add a bit more stuff to deal with GDPR, and that deals with the situation. Now, the other realm to know about, however, are other kinds of data that are unconsented and cannot be consented for various reasons. So what I call administrative data, I'm not sure about a direct German translation, but things in the realm of things the government might collect that we are now using for research but weren't collected for research purposes. Tax, employment information, this kind of thing. Similarly, in the area that I've been working on a great deal lately, data coming, new and novel forms of data, social media, and so forth. We can debate about whether or not it is possible to get consent in doing something like Twitter. It is actually possible in some circumstances, but it certainly is not easy. But it is in these realms of unconsented data where you're relying on a different grounds for processing personal data. Probably this number 5 carried out in the public interest, in which case you have a higher bar to defend your research in terms of research as happening as part of public interest. Okay. I think I shall not go too much further on that now. Okay, so I sort of wrote this as what on earth do I do now? So this is more like, this is trying to, you know, get to some of the core steps, and again, this will become more clear, I think, when we actually look at some consent forms. But essentially, when you look at materials out there, there are sets of questions to ask about how to proceed, questions that you need to have thought about and preferably have documented answers to as you go through working with your data. And there are a couple, I don't think I put it in this, anyway, I'll come to it later talking about yeah, here, it's on this page. So, Do you need to collect personal data at all, okay? Obviously, a lot of social science research is dealing with human subjects, and therefore we probably are. Not many of us can escape this at all. But it's worth thinking about, do you have ways to avoid dealing with the personal data at all? Or at least, if you can't avoid collecting it, at least collecting the bare minimum. So, for, I don't know, 10 years ago, some forms were routinely asking for information like telephone numbers and addresses. It was pointless. You didn't actually need it. It was just sort of part of the template form that got handed down. You don't do that anymore. You simply check materials to make sure you don't collect stuff that you don't need. Do pay attention to the special category data. It can show up in surprising places. It obviously, survey questions related to some aspect of any of those topics appear very broadly. Practically most major of the major social science surveys are going to be addressing some of those, many of them address those categories. So that is something to pay attention to. The sharing with partners really matters, and it especially matters if you're sharing with partners outside of the EU, the European area, because there the restrictions become tighter. Think about these grounds for processing, consent versus legitimate interest or something else. The information you need to give participants. This is laid out quite clearly in one of the sample consent forms that I'm going to show later. So I haven't done a list of the kinds of information here because I think it's clear elsewhere. Yeah, please.
Not directly to that topic, but think of research with like Switzerland or Norway or maybe in a few years the UK.
Maybe. October.
Maybe, I don't know. Do they have similar ruling with you or to you?
Okay, so I think I put this elsewhere, but let me comment briefly now. So what the EU does is that there is a classification called, what's the term that's going to escape me? Recognition, something like equivalence, something like an equivalence recognition. And where the EU has more or less acknowledged that the data protection regime in that country is good enough to match EU standards, then the transfer and exchange is more or less as though that country were in the EU. Okay, not quite, but the exchange can happen. The US had it under a program called Privacy Shield, which is now canceled and being reviewed and reassessed. In the absence of having that recognition in place, you have to have explicit consent, meaning literally a separate line or sentence in your consent form, acknowledge that your research respondent knows that the data may be transferred or shared with an entity outside the EU area, is informed about the risks of that and agrees. Okay, now with all that additional baggage, you can then do that kind of sharing. The real problem that all this comes down to is that, as we all know, the more complex your privacy statements, your information sheets, your consent forms be, the harder they are to explain, the more nervous your participants get, the less likely they are. I mean, this is the issue, really, what motivates us. So the idea is to try to, focus on, if nothing else, I continue to use a strategy, just like I do with ethics review, in fact, that data protection, the GDPR is good for data participants. They should in some ways be appreciative of it because it is enhancing their rights, but it is an extra step to explain and make clear what's going on with this stuff. Okay. Data storage, okay. And then, there's a fairly structured process, including forms and questions called a data protection impact assessment, which you might not have heard of. It's worth having a look at these kinds of tools and checklists, even if you don't think you're dealing with particularly difficult data. But I would say, if you have a number of what I would call the complicating factors, like sensitive data, international, outside of EU, so then to go through one of these data protection impact assessments, documenting the results again so that you can show what you have done, will be helpful protection. So, okay. the insert is from my colleague at the UK. I think I hit on all these points, but these were sort of her distilled sense of what was different under GDPR compared to, obviously, we had data protection laws before, so a lot of what's going on is just trying to figure out what's changed. We aren't just doing data protection for the first time. And generally speaking, for those of you working mostly within Germany and within the scope of Germany, the changes were somewhat reduced and less because the German data protection law was, I think I could say, the strongest in the world even before GDPR. So the standard was already very, very high. Okay, so that's, I mean, we'll come back and look at some of the the exercises that you'll look at. We'll look at language that's in consent forms dealing with GDPR. But as I said, I'm not going to cover copyright now or any of the other legal stuff. I'm going to turn to a few questions about ethical, ways to think about ethical issues and turning to informed consent. So I'll pause here if there are any other comments or questions. Okay. I'm always conflicted starting ethics. It happens, of course, since it's part of what I do and teach it. So I have a soft spot for it. I like talking about it. I like working with ethical theories and so forth. I realize that most people actually do not share this passion and really would like to get on and do other things. So I will restrain myself from saying too much, but again, there's sort of one myth to dispel, to perhaps try and summon up a little bit more sympathy for thinking about ethics. I mean, yeah, I have done workshops, I will say, like this. Talking to researchers about data sharing, archiving, ethics, fair, open, all this kind of stuff. 10 years plus, and not majority, but a large number, absolutely no doubt, are neutral on this topic, neutral to somewhat negative perhaps, and more or less have a question in the back of their mind going, okay, I promise not to do anything wrong, I'm going to follow the law, do I have to think about this anymore? And would just like to get on with it. And I am really quite sympathetic to that view. There is a lot, I think the pressures of people in our areas of work are increasing, and there is a lot else to do. But I guess there are two reasons. At a kind of conceptual level, law says, I mean, even, think about the way we structure laws. We have laws against things. The law tells you what you can't do. It doesn't actually help you always figure out what you should do. It doesn't answer the should and ought questions. Ethics does try to go further and address those. And I think the Ashton-Madison case that I mentioned kind of raises the point that we don't seem to be asking those questions maybe enough. But there's and I certainly am not going to go into any background at all on ethical theories here, but I think because you hear these terms and they come up in assessing research, they come up in ethics committees and so forth, they're just two approaches that I'm going to say two sentences about and then a clarification. So you will have presumably heard of this idea of assessing costs and benefits, harms and risks, this kind of language. Okay, it comes out of consequentialist philosophical theory. I will not say another word about that, I promise. But if you want to talk about it at the break, I'll be happy. Anyway, the point is, it's this idea of weighing, balancing, cost-benefit framework. Okay, there's another whole strand of ethical theory that uses language more about duties and responsibilities. Okay, that comes out of deontology. Again, only use that word once, I shall not come back to it. These are like different languages, and what I hear a lot of researchers struggling with is frustration with the fact that there are multiple approaches, or horror, the approaches might actually give me different answers, and oh my God, what do I do now? Because my two ethical frameworks are pointing me in two different directions, and what do I do? Okay, well, let me try to reposition that as, for me, it is not totally different, I don't mean not totally different, than how we approach research methods. So we might have a really complicated research question. We might collect both qualitative and quantitative data on it. We might be working at a mix of household and individual levels. We might be working cross-sectional and longitudinal. Is cross-sectional right and longitudinal wrong? No, depending on the research question, I get two different perspectives on my problem that can inform me, okay? The parallel isn't perfect, and I will grant you that. If you push this metaphor, it probably doesn't go it might not hold up. But I think it gets across an idea that multiple answers to these kinds of questions aren't necessarily a bad thing. It doesn't mean ethical frameworks are failing you. It just means you have to use them as tools, the same way you use your package of research methods as tools. Okay. Try to ground that just kind of quickly with one short example. I'm going to make sure I don't overrun here. But think about data with human rights activists and possibly like activists in their own countries or, who are in places where there are serious threats to physical harm if you stand up and try and defend human rights. Okay, we have far too many examples of those these days. Now, say, a lot of my background, it's mixed, but some of it is qualitative, so I'm going to use an example of qualitative interviews here because I think it's clearer. You've done interviews with these activists. They're keen to get their word out. They are happy to be interviewed. They want their material shared, publicized, and so forth. So the issue isn't consent. You actually are clear they are clear on what's going on. And you can assess the risks of doing this research and sharing on a cost-benefit framework, okay? And you can say, okay, maybe the benefits of sharing this research and this content is actually very, very high. It will help the activists themselves. It will help the underlying population. It will advance the cause of human rights more generally. On a cost-benefit balancing thing, it looks like the right thing to do. On the other hand, if you use the duty or responsibility, you as a researcher may look at that overall situation and say, okay, even though this individual activist has agreed, I actually think I have a stronger responsibility to protect this activist and this material more than the activist, him or herself, wants it to be protected. And I may do that because I think the risks are greater than the activist believes, because I know more from having studied the problem. I may see that there is a risk of breach of the data and the physical harm that could harm the whole public cause of human rights much more broadly than this activist might actually believe. So on a responsibility duty basis, I might override that cost-benefit assessment. Okay, so that's a short, pretty constrained kind of example about how the frameworks can come into conflict, but how it's still useful to have both of them. It is still useful to think with both of those tools. Okay. Codes of ethics feature, usually the way to proceed thinking about ethics is to pay attention to, I absolutely despise the word stakeholders in this word, but it is the word that gets used a lot. Basically, they're groups of people to whom we have responsibilities or duties. Our participants, data subjects, whatever language might suit your particular kind of research. Peers, loosely, our research community. Sponsors, funders, employers, and the broader public. Now for research participants, the main responsibilities we're usually talking about fall into this cluster about making sure it usually has to do with respecting their dignity, their autonomy, making sure that participation is voluntary. So there's a set of responsibilities that go with them. For peers, it's this idea of integrity, kind of comes back to these principles of things like, I should make my data fair, I should be able to not compromise, use good methods and good approaches, the right tools for my work. For sponsors and funders, being clear about not having conflicts of interest, and to the public, this idea about using, if you're publicly funded with tax money, certainly using that funding wisely, and making sure that overall benefits, social benefits, outweigh any harms or risks. Okay, oh no, what did I do? Wait. It just needs to wake up a little bit. It's like my husband in the morning. Okay, so consent. Let me turn now fairly quickly to consent and I'm going to talk about consent on two different perspectives here. One is consent that you need to do differently to think about data sharing, okay? Because again, this is not a course on basic ethics for how to cover your own research. It's what's different when you're talking about data sharing and what's different a little bit under GDPR. So first about data sharing a little bit. Basic consent clearly already deals with the things that we would know about: purpose, nature of participation, risks, and so forth. For data sharing and for personal information, you probably would need to make clear things like how you're processing the data and being very clear about disclosure, confidentiality, what safeguards you're using to protect the data. And this routinely covers the collection, the analysis, and usually the publishing of data, making clear how you're going to be disseminating your information. So, at the conceptual level, it is not, to me, a huge additional step to deal with the issue in a consent form and information sheet about onward sharing of data, okay? If you can explain to participants how dissemination is working in publications or websites or something like that, the idea of putting data into a repository is not such a giant conceptual leap that it should be a problem. And this brief language from a form on the UK Data Archive that you'll see more of later, does that. It simply structures the form in sections. So here are consent questions about use of the data, but while it's being collected. Here are questions about why it's being processed, and here are the questions about what happens after the end of the project. Okay, so it kind of follows a logical flow, and it's not completely difficult. So yeah, it's a bad paraphrase of the lovely famous quote that I shouldn't be mangling, but nonetheless, it's not a huge difference, and it's a small thing for a researcher to do that can make a huge difference for the scope and the scale of data that we have available for data sharing. So I encourage you to at least think about trying to do this. My point for consent forms really comes down to this. It is not your job to change your participant's mind if they don't want to share their data. That's not what we're asking you to do. The issue is you have to give them the choice, and you don't preempt the choice by not asking them. Okay, so that is the key distinction. Okay, so then adding in GDPR, again, the GDPR it is challenging. There's no doubt. There's a lot of guidance about how all the stuff you need to do to make sure that consent meets these criteria: freely given, specific, informed, and unambiguous. This is a really nice set of slides in a webinar on GDPR. By the way, I would recommend it among all the other things that we're recommending to you, but this one is short and a good summary. And of course, then they also say, oh, but by the way, make sure it's very concise and in simple language and doesn't confuse your participants, et cetera, et cetera. So it's conflicting, there's no doubt about it. You have to balance this, and the kind of material you can give to competent professional adults is very different than what you can give, if you're interviewing people with dementia. Obviously, you have to adjust this to your context. But some of the key things to pay attention to are things like unambiguous. Consent has to be positive. So consent by inaction does not work anymore. You cannot simply take a default non-response as consent. Special categories, as I mentioned earlier, need explicit consent, as does the sharing outside the EU protected area. The other thing that gets a little bit tricky is, and I'm not sure people are actually doing this in detail, strictly speaking, in the GDPR, if you are using consent as your legal basis of processing and also going through consent procedures for ethical requirements, you have to somehow separate that and make it clear to your participants that those are two different procedures for consent. I don't actually have a good example on paper or any form yet where I've seen that nicely done. If anybody knows of one, let me know, but strictly speaking, that is what GDPR says you need to do. Okay, pause, questions, comments? So, no, you cannot can't read these slides. Didn't think that you would be able to, so not a problem. I would say this is highlighting some of the great work by other colleagues on SERISS projects, by the way, on the SHARE study, the Survey for Health, Aging, and Retirement in Europe. I just grabbed a handful of the slides from it because they have done consent that is GDPR compliant, and it is dealing with sensitive data, and it's international research. And the guy who's written this PowerPoint is excellent, and I think it's published some stuff on this as well, but just the content in this PowerPoint is well worth it if you're grappling with this situation. So they address the fact that because of the linkage issues, and because of because they're not cutting the link in the data, that all of their material falls under GDPR, and they have to deal with it. There's one other thing that comes up in this that I did mention earlier that I will take the opportunity to do now. GDPR, as you may or may not know, is also combined with national law in terms of the full package of data protection. And in some cases, those national law, the idea, of course, for the EU version was to harmonize and make consistent the law across Europe. To some extent, the national laws are deviating from that, more or less, depending on various countries. It's a bit unclear how extreme those deviations are, but this particular project dealt with slight variations in national law in their consent procedures. So it's worth looking at for an example of how they handled that. Okay, do we have till 11:15? Okay, good. We're well on track, even ahead of schedule. I'm going to skip the next couple of slides for a moment on the classroom activities, because I just want to point to resources, and then we'll come back to the activities. So, these you've already heard about before. I'm only going to highlight something that's different. Yeah, Anna, did you want to? Okay. So the package on the SERISS site is, disclosure, bias disclosure. I helped produce it. I helped write chunks of the content that went into it. So of course I'm biased, but it was the work of a team of 5 or 10 or more people across the European Social Science Data Archives who've been teaching data management workshops across this whole range of topics, ethics, legal, data storage, encryption, protection, FAIR, open data, and it was the best we could distill into online course for targeted at roughly undergraduate kind of master's level students, I would say. So I hope you like it. It's getting some hits. We're revising it always, so feedback is welcome, but it's where I would start if I were looking for content for a course. Foster, I already mentioned. SERISS, lots of good stuff continuing to come from SERISS, and some parts of the project are not ending until August. Thank you. So, in particular, I've got the links to both the project and directly to the deliverables, but there's detailed guidance on linking, on working with legal and ethical issues with administrative data and with social media data as well. It will be coming by the end of the year. There's also a nice little exercise here, again, one I would use as a starter basis that's got really lousy language about consent that we got from the UK Data Archive, from all the consent forms that we have collected over the years. Obviously quite anonymized, but basically people use this stuff all the time. I promise to destroy the data. I promise your data will be anonymous, without ever saying what that means or what will happen to it. I promise no one will ever see your data again. And then the information sheet says, oh, by the way, I'm using a transcription service. Okay, so you get the idea, but it's easy to use this kind of language, especially when we're trying to build trust with our participants and so forth, but it is damaging to data sharing and so forth. Okay, pictures, just so you know when you get to the right website. That's why I use them. References. This could be boring, but I want to say a couple things about some of these that are really good. If you're working at all with social media, do look at the work by Magal, Sloan, and others. It is exceptionally good on linking Twitter and survey data. Or for that matter, if you're linking survey with anything else difficult, I would recommend looking at their work. They're outstanding researchers and publishing a lot in this area. If you're looking for an example of how to actually use Twitter to get consent in a qualitative realm, that's not my work, but my co-author, Daniel Gray, did a nice case study for his master's thesis doing that. I should have written out the acronyms. European Social Survey, Privacy Notice, so sort of a light touch on how to inform participants, where you link to a privacy information page that gives the details on GDPR and stuff that you need. ICPSR, Big Data Archive in the US for social science, they have some nice language where they again show bad language for data sharing, but then give you some good alternatives. And again, not necessarily stuff you would only copy paste, but copy paste and edit and adapt to your situation. This is, Schnieditz is the author on the work for share where I showed you the 4 slides earlier, and Sloan's is more work on Twitter, so just a few highlights there. And I think there are a lot more references for, I think, in the Foster materials and on the CESTA guide and others. Okay, so classroom activities. You know how to structure a classroom activity, so I'm not going to go into a lot of detail on these things, but I'm going to, I think since we've got this much time, I'll hand out, I've got 3 things, okay? And I'll just say a little bit about them, and I think we'll go into two groups and chat for 10 minutes and just about them and how you think they might work, and then maybe get a little bit of feedback just after coming back from the break. So, one form that I think you already have is a consent form for qualitative interviews. Don't know if you're doing that kind of work, but it's for starter researchers that relatively inexperienced people. I would say it's a gentle introduction to dealing with language, how to think about why it's so easy to put wrong kind of language into a consent form, and how to think about changing it. Yeah. Yes, okay, so these 2 forms, because I had this in advance, are in your folder, and then the third one that I'll hand out in a minute you don't have, but we'll send it to you later. So one of these is, the consent for data sharing and reviews. The other is a template, and I use the term quite loosely, but for consent with GDPR that is from the UK Data Archive, and I think you can, the focus actually is much more on data sharing. You have to look a little bit harder to think about how you would adapt that to GDPR, but I think you could use that in the context of one of your own projects or a project you know about, and decide how you might adapt it. Then the third one I'll hand out is actually, I think, quite useful. It is a consent form written out with categories of information provided that are GDPR compliant, and I think that makes it clear kind of what new things you need to add to deal with GDPR. The third form I'll hand out is a little bit less about it. I don't think it deals with data sharing at all. So what I would suggest, for the sake of better conversation, you guys are from the same institution, right? So can I ask you to go sit over there so you don't just talk to each other? And then kind of look at these forms, I would say for 10, 15 minutes, and just have a chat. Do you think you could use them in a classroom situation? If not, what else might work better for you? And we could have a short conversation about that, perhaps after we come back from, or just before we go for a break. Okay? And I would use your judgment. If you want to look at only one form, that's fine. If you want to skim all 3 and talk about them, none of them are, well, the one is actually quite long. You'd have to just skim that one, but I'll hand that out quickly.
Just gonna get to grounds.
Well, just to plug, the entire online data management guide from the CESTA source is built around the idea that you're writing a data management plan for your own project. And you can do that. You can do that as an undergraduate project or European Horizon 2020 scale.
Then it will also take different forms,
Mm-hmm.
and then we could discuss on that.
Okay. But and here's the interesting trick. I mean, if you collect more forms, but it's actually pretty challenging to get people who are completed forms to give them up and allow us to use them directly for teaching, okay? Because the area is so new and people are paranoid about the legal consequences and so forth. So to put a form up, they'll use them and they'll share them. So if you can find people who are doing the research, just talk to them and you can usually get a hold of things. But for us to say we want to take it, put a copyright, a CC license on it, publish it, and put it forward as good practice for how to be compliant with GDPR, they go, oh no. And I appreciate that. It's scary. That's one reason why the SHARE and some of the other big surveys are good examples, because they are dealing with it.
You can also have a look at the disciplines course. Because we have, this is sometimes very inspirational, for example, in the Consortium, in this course, data protection and ethics. We have, I think we have a number of examples, and the interesting thing there is, this was an interdisciplinary project, so it's not all social science.
I was in Lille in France a few months ago. We had a long course on big data as researchers. So there, and we had a whole day on these topics and in the end we arrived to a conclusion that it's so complicated for research. So it was like knowing this exists, knowing we have to be aware of, knowing, but in the end when we come really to the point, if we want to be covered, there was in each university like a person that is becoming to come in charge of revising the project, if they're legal or not, because there's so many things in between. So we as researchers, we are aware of it and we know the limitations, how this do this. Mostly in terms of anonymization of data. No? Which is now, for example, we came to the conclusion that it's impossible to anonymize.
Yeah.
There's always a track, there's always, if you want to find, now you will find who's who, even if there's no name there.
Yeah,
just crossing the other data that you have.
I'm glad you raised that point, because I didn't stress it enough. You know, there's an obvious, you know, if your university provides support in these areas, whether it's data through your librarians.
Researchers for that.
Exactly.
But then the risk, and we were discussing on who comes the responsibility, and it comes on the head of the department.
Okay, right.
It's like, so there's a really a legal thing here.
Yes,
you know,
exactly.
that is to specific or to professional for us as researchers in the university, just to cope with it and say we're covered, because not necessarily, it's much more complicated.
Okay. Any other thoughts from your group? Okay, thanks. What about you guys?
So I'd like to come back to the question you asked first about discussing that in class, because I think one additional advantage would be, especially if you do it with, you know, bachelor degree students or something like this, is a kind of empowerment, because especially in psychology we use student populations a lot. So, you know, during their study time they would raise from 30 or 40 surveys, questionnaires and experiments, and always would read this kind of consent form and probably just, you know, skip over the important parts, take it and sign it and off we go. So maybe it's also kind of awareness, what do these phrases mean, what is happening behind the surface, so to say. Especially also if we have this project, what do we do with the data, and how do we need to put it into the consent form, etc. So it's actually, I like the idea.
Good. Yeah, and just again to point, I don't know what's collected here in the data repository here. I'm sorry, in some ways I'm more familiar still with some of the features in the UK system, but in the feature on the UK data service site called Reshare, which holds data collections, consent forms are collected also. So if you have a particular thematic area, you could go into that archive, search for data collections on, say, psychology, and see if there are actually sample consent forms that have been deposited with the data that might be interesting to look at. So that's not always deposited, but in many cases they are. So, any other thoughts from your group? Is this,
No, then I was thinking, are people really so picky on these things? Because then we give data just like that, you know, so many applications, you don't even give them, you know, it's like, we're all really so irresponsible in the way we share data every day. That, do you think people are really going to read and go through this, or will we just take...
That's the big question, of course, is the rest of the world is so messy, why do I have to make my life difficult complying with GDPR?
No, we have to.
Well,
but in the end, will it result in being like this so complicated or not?
I can only say, if I were doing active research now, I would follow exactly the advice that I'm giving you here. Okay, I'm serious, and I would from the standpoint of on two fronts. On data sharing, I mean, I have done research and shared the data from that. So, you know, admittedly, it was not a particularly complicated situation to do it because I was interviewing professional adults who understood issues about data. So, you know, it was relatively obvious. But nonetheless, there was extra work to go through on consent form and handling, you know, interacting with the archive and so forth. So it's not trivial. I appreciate that it is additional work. On GDPR, the main message, again, I will come back to just because I think it's the most important one, transparency and documentation. So, you know, be clear what you are doing, what data you're collecting, on whom, why you're doing it, and be much more thorough and systematic about documentation. Informal records just, you know, will not suffice anymore. It's not that you don't probably have the information, it's a matter of collecting it in a systematic way. And since for me that's easier if I follow a template like a privacy assessment or somebody else's checklist, that's where I would start. Some other questions might occur to me that aren't on those lists, and that's fine, but I think those basic lists are a good starting place to make sure you've covered the relevant points. Again, looking at the 6-page longer consent form here, you know, this is the kind of thing I would use as a template to start. Does this cover the categories that I care about, and so forth. So, one more.
Yeah, so talking about this form, we've been discussing a little bit the purpose of the study, for example, also the procedures up to a certain degree, because if we share the data afterwards, then of course there's always, you know, other people can access the data and do reanalysis and go or look at the data with entirely different perspectives and research questions. So the purpose of the study, as disclaimed by me as principal researcher, is not the entire story, so to say.
That's right, and that's the, you know, that is the nub of the issue. In some sense, you cannot satisfy this requirement of detailed, explicit consent about reuse when you put it into an archive, because you don't actually know. So the language around that is more general. It will be held in an archive. It will be held in certain ways. If in order, under conditions of your research, if there are restrictions on how that material can be reused, you can, in some cases, not all, but in some cases, you negotiate with your archive or repository about maintaining those conditions on the data collection. And then you can make that commitment. But yes, you have to be, but again, there's nothing in GDPR that prohibits this idea of reuse, even for different purposes, as long as it's for historical, statistical, and research ends. So. Okay, well, I kept it a little bit long, but I think that was a useful conversation. And again, if you have feedback, these materials are not in the final form, and I guarantee they will go through multiple iterations. So if you have particular suggestions or something you would like to see, get in touch and let us know. Okay, let's 10-minute break. I think should do it. Is that right? Thank you.